against the requirements of Article 138(3)(c). Secondly, my lords, the submissions by learned friend, Senior Counsel, Professor Githu Muigai, on the executive status of the chairman of the IEBC, I think should be taken with a pinch of salt, because Article 249(1) of the Constitution does not contemplate an imperial chairman who is all-fearing with fear, favor, fervor, and fiat. That is not the chairman that we have. The chairman of the IEBC, appointed under Article 250 sub-article 4 of the Constitution, must be that chairman who is a first amongst equals, just like the Chief Justice of the Supreme Court. A primus inter pares who must work with his colleagues to guide the affairs of the Commission. I urge the Court, therefore, to decline an invitation by Professor Githu Muigai that the chairman of the IEBC is in a special position, different from the 4 commissioners who are crying aloud to be heard by this Court. And my lords, this petition number 5, as consolidated, therefore tilts on the violation of Article 138(3)(c). It tilts on that violation. And that violation alone, my lord, therefore invites this Court to look at or to turn to Articles 23 of the Constitution on your role as a court to interpret the Constitution in a manner that goes beyond just protecting human rights, my lords, but to look at what would guide your interpretation, the holistic approach, the purposive approach, and let me borrow my learned friend's approach, the Antonin Scalia's approach, the late judge of the U.S. Supreme Court, the textual and the contextual approach. And if you apply those approaches, my lord, then you will find that the chairman of the IEBC, in failing to properly construe his role under 138(3)(c) and 138(4), violated the Constitution, and an unconstitutional process therefore emerged that cannot put into place, my lord, a process that violates Article 3(2). My lords, there is an invitation to you to invalidate the entire process. And that is why, in answering the Supreme Court judge's question that was directed at me on remedies, I wish to state that, and this is because this court also has a purpose under Section 3 of the Supreme Court Act. And given that you're an election court under 84, in an ideal situation where you are construing Section 83 of the Elections Act, which must be interpreted disjunctively, because if there's an unconstitutional act, then the election cannot stand. If quantitatively, as we shall demonstrate, there is non-compliance, again, you'll have to invalidate the election. But my lord, in an ideal situation where you'd have been called upon to apply Article 232 on public service and Article 201 on public finance, you would have ordered a recount and then secured a winner. But this would only have been possible if there were no unconstitutional infractions that undermine the process and therefore make it unconstitutional. Because this is no longer about tallying and verification. It is about the bigger process of the involvement of commissioners and a split commission. And the only remedy available, my lords, Justice Ouko, the Chief Justice and member of the court, is a nullification. This is no longer the baby of Raila Amolo Odinga V. This is no longer the baby of William Samoei Ruto, Dr. the First Respondent. This is the baby of Wanjiku. It is the baby of Kenyans. Return this baby to Kenyans to determine to whom they shall hand over the baby after 60 days. I pray that you nullify the election. And I will cede my time now to Mr. Senator of Busia County, Okia Omtata. the perennial litigant. Thank you.